Good morning, Mr. Hunter. You were charged with unlawful carrying of a weapon. You're facing up to a year in jail and/or a $4,000 fine.
Right from the start, Judge Fleischer wastes no time. This isn't just another day in court. The stakes? Up to a year behind bars and a hefty fine. But notice how calm the judge sounds. That's the tone of authority built on experience.
We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Officers were conducting a trespass investigation at a gas station in a high crime area where narcotic/gang activity frequently occurs. Officers observed the defendant's vehicle parked for approximately 30 minutes in front of a no loitering sign at the gas station. The officers approached the vehicle and observed a strong odor of marijuana. Officers then observed in plain view a handgun between the driver's seat and the center console.
All right, Mr. Hunter, I'm going to find that there's probable cause to go forward with your case.
This is a textbook probable cause hearing. The judge's role right now is not to decide guilt, only to decide if there's enough evidence to proceed. The smell of marijuana and a visible handgun? That's already strong probable cause.
Do you have a valid Texas driver license?
No, sir.
You are not allowed to drive.
Sir.
Do you understand?
Yes, sir.
If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
Conviction or parole at this time?
No, sir.
When the judge asks about a valid driver's license and hears no, the tension spikes. He's basically warning, one more bad choice and I'll double your trouble. Imagine being told that every drive could land you back in jail. Terrifying, right?
You are now working your 4th case within the last year, your 3rd gun case. Tell me, what do you do with yourself? Do you work?
Yes, sir.
What do you do?
I'm a family dog.
Do you work full time?
Sir.
How much money do you make a month?
Between $1,600.
I'm glad that you're working. I want you to continue working. Did you graduate from high school?
Yes, sir.
You did? Great. Okay.
Now, Judge Fleischer shifts tone from strict law enforcer to mentor. He digs into the man's life, job, and education. Why? Because context matters. The judge wants to see if there's potential for change, or just another repeat offender.
Do you want to apply for an appointed lawyer?
Yes, sir.
Okay. No more dope. I'm going to test you. And if I find that you continue to smoke dope, it's not going to go well. Do you understand me?
Yes, sir.
I will test you 40 to 45 days from today. If you test positive, it's not going to go well between us. You stop now. Do you understand?
Yes, sir.
There will be consequence because it's the 4th case, and I'm ordering you now not to consume alcohol or illegal drugs, and I'm going to test you like crazy. Do you understand?
Yes, sir.
I'm going to get on an application. I'm going to have you come up here, swear test that you're not going to drive.
No more dope. It's not just a warning, it's a lifeline. Judges see patterns, and this is his 4th case. Fleischer's making it personal. Fail one more test, and you'll feel the full force of the law. It's that fatherly mix of tough love and justice.
I'll get you to Stephen fill out the application. We'll have you sign a receipt with Victoria, and then we'll have you hang tight.
Will there also be state farm conditions?
No, because I'm going to monitor him, make sure he's not using. So we'll just, everything will be drawn.
Next is page 10. Mumford.
Did you say they found weed on him or no?
I don't think so.
What is your last name, Chief?
Mumford.
Mr. Mumford, you're charged with terroristic threat.
And just when you think the courtroom tension might cool down, a new defendant enters. Different case, different charge, but the same judge. This time it's a terroristic threat. Let's see how this one unfolds.
You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On October 4th, 2024, officers were dispatched to a call at a parking garage in Harris County, Texas. Officers made contact with a complaining witness who stated that she and her coworkers, including the defendant, were working inside the parking garage. And the complainant messaged the defendant asking where he was located, and the defendant suddenly arrived at the 3rd level where she was located and began to yell and scream at her. The complainant stated he threatened to beat her ass.
Were they together at the same place?
They were on the same, so they both work at the parking garage, I believe, and they were both on the same level. Like it was in person, the threat was made in person.
Did you say she was in fear?
I don't see that in the Dunes, Judge, but let me really quickly the offense reported. I don't see that alleged in the OR, Judge.
So the only thing the state would say, Judge, is our position is, I know it doesn't say that complainant said she was in fear for her life, but the charging instrument, it's not one of the elements we have to prove. We just have to prove that the defendant intended to place the complainant in fear of serious.
I don't know. Let's see.
The prosecutor argues they don't have to prove fear, only the intent to cause it. That's a subtle but crucial legal difference. It's what often decides whether words are considered free speech or a criminal threat.
A person commits an offense if he threatens to commit any offense involving violence to any person or property with intent to place any person in fear of imminent serious bodily injury.
So, and Judge, just to remedy the issue, we checked the probable cause affidavit on the charging instrument. On the PC affidavit, it does say that she stated she was in fear for her life.
That's the only thing I want to know is she in fear? How do we know?
Yes, Judge.
Because a lot of people make these stupid ass threats all the time, and it's just,
I understand, Judge.
tell me what it says. And does she say that she was in fear?
Let's see. Oh, it does say that the defendant came to level 3 where she was located. He began to yell and scream at her, threatened to beat her ass. She stated that this scared her and made her in fear of serious imminent bodily injury.
And where is that?
This is in the charging instrument, the PC paragraph.
That's just the charge. But I get it. That's just because they put that in the charge. Nowhere in the OR does it say that she's in fear. Nowhere else does it say she's in fear. That's just because they always put that on every information with regard to this.
I understand, Judge. And
Yeah.
the only position we have is that it's not one of the elements the state has to prove.
I don't agree. I'm going to find no probable cause in your case. The only thing I'm going to tell you is be careful, really. Words
Yes, sir.
have meaning. Words can hurt, right? Pen is mightier than the sword. Words can hurt. Just be careful, all right? Okay, take a seat there, please.
Judge Fleischer delivers a powerful message. Words can hurt. He rejects probable cause, meaning the charge won't move forward, but still drops a life lesson. This is courtroom wisdom in motion, justice with a human touch.